Hello and welcome to Sherayzen Law Office video blog. My name is Eugene Sherayzen. I'm an international tax attorney and owner of Sherayzen Law Office Ltd. And today I'm continuing my series of blogs from Austin, Texas. And I'm standing in front of the IRS campus here in Austin, Texas that processes voluntary disclosures, in particular streamlined disclosures, streamlined domestic offshore procedures and streamlined foreign offshore procedures. What I would like to do in this blog is to discuss streamlined domestic offshore procedures. What is it and why it is important? First of all, streamlined domestic offshore procedures is an offshore voluntary disclosure option. In a previous video, I discussed what is an offshore voluntary disclosure. Briefly, let's restate that an offshore voluntary disclosure is basically an option that the IRS provided to US taxpayers, or I should say a set of options that the IRS provided to US taxpayers in order to come forward and resolve their prior non-compliance with US international tax laws in exchange for a more lenient treatment, a lower penalty, an immunity from criminal prosecution, etc. So where does streamlined domestic offshore procedures fit into this picture? Streamlined domestic offshore procedures, or SDOP, is reserved for non-willful taxpayers. So people who, for example, didn't know about the fact that FBAR existed, or they didn't know that they needed to report their foreign income, or there was something that happened that prevented them from learning about it, or they were just negligent, not reckless, but just negligent in their compliance. That is, they did not consult an attorney in time, or there was something else, some other circumstance in their life that prevented them from complying with US international tax laws. So for these taxpayers who are non-willful, the IRS gave this option, and it's a valuable option. It's a good option. In fact, as far as the voluntary disclosure options go, streamlined domestic offshore procedures is one of the best options available. The penalty is relatively low. It is 5% of the assets that should have been reported on FBAR or any other international information return. A one-time 5% penalty on the highest of the past 6 years. There are no penalties for income tax non-compliance. You just have to pay taxes and interest on the tax. But there are limitations to this option. First of all, you cannot file a late return pursuant to streamlined domestic offshore procedures. You can only amend an already filed return. It can be a problem, especially for taxpayers who, for one reason or another, couldn't file all of their US tax returns on time. Second, you have to certify under the penalty of perjury that you were in fact non-willful. Now, this subject is very sensitive and very important. Here, you must really talk to an attorney to figure out, are you non-willful according to the US legal standards, or are you willful with respect to your non-compliance? There are a lot of facts and circumstances that go in that determination. You really need to talk to an attorney. I cannot stress enough before you try to do a voluntary disclosure. The IRS has expressly stated that they will go after the cases where they think that people are abusing streamlined domestic offshore procedures, because in reality they were not non-willful, but they were willful. If you would like to learn more about Streamlined Domestic Offshore Procedures, you can call me at 952-500-8159, or you can email me at eugene@sherayzenlaw.com. Thank you for watching. Until the next time.